Welcome back to season 4.
No, it is season 2.
Oh, season 2 already. Hey everyone, Terry here. Welcome back to Simply Legal. We have now launched season 2. Thank you so much everyone for joining us in season 2. Without wasting any time, today we're talking about wills as our first video on season 2. And let's dive into the subject matter of wills. So what is a will? Who can make a will? In our day-to-day life, many people are battling with marital issues. They're battling with family issues. Inheritance. Actually, this is the genesis of where a will came from. To inherit. Inherit is to get something from your forefather, or for someone to easily get something that they have not ideally worked for, but someone had wished it for them. In Uganda, many people are battling with many family issues, marital issues. However, today Simply Legal is here to clear the air on wills. Therefore, what is a will? A will is a document that basically allows a testator, who is a person who is about to die or wants to give away his property. He puts it in written form and he basically stipulates how he wants his estate to be governed. What is an estate? Many of you may be asking. An estate is basically the property that I have been amassing throughout my lifetime. It could be land, it could be buildings, it could be anything. Many of you have buildings in Chikubo, people have buildings in Chanja, people have rentals, land. Personally, I want to get all of those things, but I'll make my will with time. But anyway, so like I've explained to you, a will in simple terms is me, Terry Kahuma, I'm getting a will, I'm getting this document, and I'm expressing in simple terms how I want my property to be governed. It could be with my children. Many of you have children. Many of you have dependents. Many of you have grandparents, wives, husbands, people who are depending on you. So that is a will. This definition of a will, I've simplified it for you, but in accordance with the law that governs wills is in relation to the Successions Act, Cap 162 of Uganda. So these are the laws that govern inheritance laws. So the Successions Act, Cap 162 gives us Section 2, which gives us that definition of giving you of a will. That a will, let me just repeat it one more time. A will is a document, in simple terms, expressing what the testator does or how he wants his estate to be governed. I've already told you an estate is a document, or an estate is a group, a set of your property that you've amassed in your lifetime. So now that I've expressed to you what a will is, I should also tell you who can make a will. Yes, I've just said it, who can make a will. Not everyone can make a will, but for purposes of Simply Legal, let me simplify the law for you. According to still the Successions Act Cap 162, we have Section 36. Section 36 has subsection 1 and up to subsection 4. They clearly stipulate who can make a will. Number 1, a will can be made by a person of sound mind. Now, who is a person of sound mind? A person of sound mind is someone who is not insane, in simple terms. Someone who is not in Botavika, someone who is not in rehab, someone who can reason like me and you. Someone who can know that this is a tree, I'm not insane, I'm not under the influence of drugs. That's number 1. Like I told you, all of this is under Section 36 of the Successions Act. Number 2, the person who is making the will has to be above the age of 18. Yes, minors, post-millennials, Gen Z, all you guys, sorry guys, you guys are not part of making a will because I'm sure most of you are below the age of 18. However, a minor, I'll go into that later on. A minor can also do a will, but in the presence of a mature person. So number 3, a married woman is among the people who can make a will. A married woman, because in most cases, in inheritance laws, especially here in Africa, many people say that it's a man who died, left his will, let's say family, let's say inyumba, houses, everything. That was me speaking in Uganda. However, so a married woman can also make a will. There are many people who can make a will, as long as you're above 18, as long as you're not a minor, and a minor is someone who is below the age of 18, a person of sound mind, a married woman, and of course a married man. someone who, even if you're not a married man, as long as you have amassed property and you have children or you have dependents, some people who depend on you for a livelihood, people have been benefiting from you. So you're leaving behind this property for them to benefit from it, because as we all say, life and death are two things which are entwined together, and we all have to die at some point. So what are you leaving behind is the next thing. So let me take you straight to the next part. Before I forget, I never mentioned the last parts of people who can do a will. I had mentioned them. We have people the ages of above 18, people of sound mind, married woman and a married man. However, there are people who also can do a will. Briefly stating, these are people of unsound mind, minors, and basically people who do not fit the criteria, like I had mentioned under section 36 of the Successions Act, Cap 162. Now, aside from that, I had never mentioned to you the second part of wills, which is very important. For you to understand what a will is, we need to understand that there are two types of inheritance, the two types of principles under inheritance law. We have intestacy and testacy. Now, when we talk about testacy, this is testate. It comes from the original definition I gave you of who a testator is. A testator is someone who makes a will. Therefore, if Mwami Terry Kahuma dies, and they say that, oh, Mwami Terry Kahuma had died testate, it means I died while I left a will behind for my family, for my dependents, and for my friends. That means Mwami Terry Kahuma, or Mr. Terry Kahuma died testate. He died when he left a will. Now let's go to intestate. Intestate basically means I died without leaving a will. Now that will be a video for another time. I'll do another video. Someone requested me to do a video of intestate laws. But when someone dies intestate, they say, oh, Mwami Terry Kahuma yafudenga talese will ye. For those who are new to my channel, that's Luganda for basically saying Mr. Terry Kahuma died without leaving a will behind. Therefore, his estate, no one knows how to govern it. Therefore, under intestate laws, this basically means that my family, people who have succeeded me, this is my family, my wife, whoever it is who I've left behind, will now go and chase what are called letters of administration and other things that I'll talk about, because family law is really huge. But today I'm introducing you into wills, just briefly. Therefore, let's now go to beneficiaries of a will. Who can benefit from a will? People who can benefit from a will, I'll make it very simple for you. Children of the testator or of the deceased. We have legitimate children, we have illegitimate children, we have the wife of the deceased, or it could be the husband of the deceased. It could be grandparents, it could be great-grandparents who are still alive. It could be children who are also above the age of 18, because according to law, the moment you're above the age of 18, you're an adult. However, you might have not gotten a job, someone like me who still doesn't have a job. So as long as you were a beneficiary, in other words, let me summarize, as long as you're a beneficiary to the deceased person, either a beneficiary to your grandmother's estate or grandfather or father or mother, you are entitled to be a beneficiary under the succession laws of Uganda. Therefore, let me now take you to the features of what constitutes a valid will. So what are the features of a valid will? Many of you may be asking, you already told us about a will, Terry. You've told us about almost everything, but not just yet. There are many features of a valid will, and one of them is still under section 36, like I told you, of the Successions Act. We have what is called testamentary capacity. These are all of the things I had given you into who can make a will. All of that is what is called testamentary capacity. This is the thing I told you of. You have to be of sound mind, you have to be someone who is above the age of 18. However, according to the Successions Act Cap 162, there was a bit of a discrepancy, a difference between someone being above the age of 18, but the Successions Act says the age of 21 years. So there was a bit different, but anyway, you're supposed to be an adult of sound mind. You must be a married woman, married man, someone who is not insane. Yeah, so that's testamentary capacity. Then we also have what's called the intention of the testator. This intention of the testator was brought about in a case called Banks versus Goodfellow. It basically talks about a person should be of good sound mind. A person should be In simple terms, a person should be knowing what they are doing. This is what the case of Banks versus Goodfellow tried to bring out. It's a very old case, but these old cases brought out principles, and later these principles became sections and laws into which the Successions Act is right now. So Banks versus Goodfellow for law students is something that you should actually look at with time, and you should look into if you want to fully understand family law. However, let's continue. Another feature of a valid will is that it should be made out of free will. It should be made without coercion. It shouldn't be made out of force. It shouldn't be made out of guilt-tripping someone. For millennials and Gen Zs, you know what I'm saying. So these relationships, so you say, you've not come to see me, what am I, I'm angry at you? No. Everything in this world, let me just digress a bit, everything in this world should be made out of free will. Likewise, this is how wills should also be made. A will should be made by the testator. In fact, in most cases, they even encourage them to be alone. In most cases, people who make wills are in rooms alone, or they're with their lawyers, or in most cases they're alone, because one of the features of a valid will, which make it valid, is that it should be made out of free will. There are many cases in Uganda where people have made wills. The family has forced the testator to write the will when he's drunk or when he's sick. In most cases, when he or she is critically ill, they make him sign the will. Signing a barua, you should really make me the heir. Give my son this, give my mutabani this. So it should be made out of free will. There shouldn't be any coercion. There shouldn't be any undue influence. And actually, this is bringing us to our next point. These are basically, we are going to our next point, which talks about what makes a will void ab initio. So before I wrap up on the features of valid will, there are a few more things you need to know. That's number 5. I had left number 4. So this is number 5. Number 5 is a valid will should be able to appoint an executor. Who is an executor? Most cases, the executor might be either the legal heir or the customary heir, but the executor can even be a different kind of person. So the executor is basically someone who is going to govern the property by which the deceased has left. So the executor is basically me. I'm the person who is going to distribute the property in accordance to the will. Remember, like I told you before, in a will, one of the things, the hallmarks of a will, is that the words of the testator, the words of the deceased person who is the testator, should be well respected without altering any word. Because if a will is ever taken to court, the judge will ask that, yes, this will has a dispute, but were the words of the deceased respected? Because even in the features of valid will, we also have his or her burial rights, his burial wishes. If he or she wanted to be buried in Masaka, and you buried him in Chotera, they will actually tell you that go and exhume the body, take it back to where he wanted to be buried. So, like I told you, the executor must be appointed in a will. That's also what makes a will valid. Another thing that makes a will valid is that it should be signed by the deceased person who is a testator, the person who makes a will. Another thing is that it should be attested to. Basically means that it should be represented in the words, in the wishes of the person who is a testator. And finally, I had forgotten to mention this, but let me just make it very clear. There are 2 types of wills. We have privileged wills and unprivileged wills. All that we've been talking about are unprivileged wills. An unprivileged will meaning that the will was made in ordinary circumstances. It was made in ordinary way, like a normal day without any crisis. I'm the age of 50 years, I just decide, you know what, let me make a will. Anytime I may die. I've grown, I've amassed property, I'm a billionaire, I'm a millionaire, so I want to leave my property to who I want to leave it to. I have maybe 10 children, I have a wife, I have dependents, so that's an unprivileged will. However, a privileged will is something that is made in most cases in the line of fire, which is the line of war. Privileged wills are basically given to people who are giving their last dying wishes, especially in combat. Privileged wills are given maybe to soldiers. In most cases, they're given to people who are in war, people who are in battle. So these are privileged wills. And in most cases, privileged wills are given orally. Now, all that I mentioned in terms of the features of valid will are stipulated under Section 50 of the Successions Act, Cap 162, especially the part that it should be signed by the deceased, it should be attested to by the deceased, it should be able to appoint an executor, a legal heir should be appointed. you should have testamentary capacity, and you should be someone who has not been coerced. It should be out of free will. So those are all of the features of a valid will. This is what makes a will valid. Still, this is under section 50 of the Successions Act Cap 162. So let's go to the final part where I'll be able to describe to you what makes a will invalid, what makes it cancelled, what makes it not a will anymore. So what are the factors that make a will void? What are the factors that make it invalid? Because we've all talked about what makes a valid will, but now let me tell you what makes a will invalid. A will, in simple terms, the things that make it invalid are fraud, undue influence, mistake, and coercion. Now, I had done a video earlier on some time back about what the factors that make a contract invalid, and these are almost the same principles that make a will invalid. So let me just explain them briefly. Fraud. There are many times where many people want to make a lot of money out of a will, or they want to steal the other person's property. So fraud are one of the things that make a will invalid. For example, if you've maybe forged the will, if you've even obtained the will in fraudulent ways, if you've done it, because the definition of fraud is basically altering the truth. There was a very famous land case of Frederick Zabwe versus Orient Bank. Yes, Frederick Zabwe versus Orient Bank. This basically gives out the definition of fraud. Yes, also it does it in land, but this also applies in family law. So fraud, the definition of fraud in accordance to Frederick Zabwe versus Orient Bank is the intentional altering of truth to suit a person's selfish need. So basically, fraud in terms of a will are something that invalidate a will. Number 2, coercion. You have basically seduced a person. You've manipulated him into signing you into the will. I've watched many movies, many series. They even happen in real life. In regards to someone who finds out that the person who is making the will or has the intention of making a will has not included them. So they use alcohol, they use, for women, they use seduction. You can use even witchcraft, if some of you believe in witchcraft. So basically coercion is you're manipulating someone to including you in the will, or even giving you all the property. Unfortunately, many third wives, second wives, they do that so that they remove all the property from the children of the first woman, especially of the man. So we've looked at fraud, we've looked at coercion, undue influence. Undue influence is like force. So force is basically you're putting someone on gunpoint. You're putting them, you're saying, Terry, you must sign this will. You must sign all of your property to your friend. In fact, it's your friend who is even making you sign all of this. So undue influence and fraud. If you refuse, boom, they shoot you off. So mistake. We also have mistake. A person who might not have wanted to do a will, maybe let's say he's of unsound mind, he could have made the will, and when he snaps back into his senses, he says, oh, actually I had not even wanted to do this will in the first place. So yeah, that's basically it. The factors, like let me just go through them again. We have fraud, we have undue influence, we have coercion, and we have, what else? We have force. So those are the major ones. However, there are also other things that invalidate a will. For example, for there to be a valid will, it must also be signed and attested to by 2 witnesses. So these 2 witnesses must also be there when the testator is making the will, because there's always a section which is left for the witnesses to sign, and there should be 2. So if the judge goes into a case, if a case arises concerning a will and finds out that the 2 witnesses were not there, or they didn't even sign to the will to show that they have actually seen the will, they knew the testator and everything, if the 2 witnesses' signature is not there, then the will is also invalid. So thank you so much for listening to me. I wanted to give you a brief about a will, what are wills, how are wills conducted, because this has been a long-awaited video because many people are suffering with these kinds of issues. So for those of you who are new to my channel, feel free to hit the subscribe button. Welcome to season 2 again. More blockbuster videos coming your way. For those who are new to my channel, hit the subscribe button, hit the notification bell so that you don't miss our weekly uploads. And for those who may not be satisfied with the video, hit me in the comment section. hit me also in the comment section about future videos you want me to do. For my fellow lawyers, if there's something I missed out in the video, hit me in the comment section. Of course, you have to keep within our community guidelines of YouTube. Do not send any hate messages. Don't say anything that's going to make your fellow counsel look bad. So for those who are new to my channel, thank you for everything. Thank you for loving me. Thank you for Simply Legal. And I love you guys so much. Mwah. Thank you so much for the channel. And I'll see you next time. Adios.